Welcome everyone to part 2 of our 3-part series on the Illegal Migration Act. Today we're looking at challenging limbo, age assessments and new trafficking exclusions. Yes, as I said, this is the second in a 3-part series of hybrid events looking at the new act. The first event looked at detention, and that is on our YouTube channel, so check that out. And the third event will look at third country removals and interim relief, and that will be on the 29th of November, so sign up for that one as well. Our excellent legal panel today will be discussing the legal consequences of refusing to process claims for asylum made by those travelling to the UK irregularly, for example by small boats. Then turning to look at changes to age assessments under the Act, including the removal of the right to appeal. And then finally, we'll be looking at the new trafficking exclusions in the Act. So first up will be Ronan Toal, who will be discussing challenging limbo. Ronan's practice covers all areas of asylum and immigration and includes cases concerned with human trafficking, claims for judicial review and policy in relation to trafficking victims, challenging NRM decisions, civil claims for violations of victims' Article 4 rights, and exploration of remedies to protect victims, excuse me. Ronan is also the editor of McDonald's Immigration Law and Practice and is ranked Band 1 in the Chamber's Bar Guide, so he is very well placed to address you. So now I'll hand over to you, Ronan.
Thank you very much. Stand here. So I'm going to talk, roughly speaking, about 3 aspects of limbo and avoiding limbo. I mean, firstly, the extent to which the Act results in claims being disregarded, and that's the word used in one of the headings in one of the provisions, that asylum and human rights claims will be disregarded. I mean, does it in fact have that consequence? Secondly, I'm going to talk about ways in which it might be possible to avoid claims being disregarded and to make the government consider them. And then thirdly, about access to a suspensive remedy and whether the Act will completely prevent interim relief being granted by the High Court or the Tribunal. So that's what I intend to talk about. Just by way of preface to what I'm going to be saying, the Act, Section 1 of the Act sets out what the Act intends to achieve and general principles that are expected to be applied. And it's quite a nasty part of the Act. But what is very significant, I would say, is that it does not include any provision to disapply Section 6 of the Human Rights Act, which of course is the provision that it's unlawful to act incompatibly with human rights. And I say that because the Act does disapply Section 3 of the Human Rights Act in relation to this provision. Section 3 is the provision that requires statutory provisions to be interpreted consistently with convention rights. So the fact that it disapplies Section 3 makes it all the more significant that it does not purport to disapply Section 6. And it also does not seek to disapply Section 4 of the Human Rights Act, which is the provision allowing or enabling the court to make declarations of incompatibility if it thinks that a statutory provision is incompatible with human rights. And if we continue to have the government that we've presently got, then a declaration of incompatibility wouldn't really be worth the paper it might be written on. But if we get a change of government, then it might be a good thing to get declarations of incompatibility, because it's something, declarations of incompatibility might help to persuade the government, the future government, to change this legislation. So that's by way of preface. The primary targets of the Act, as we know, are listed here. They're set out. Are they listed there? No, they're not. Section 2 identifies the people that the Act primarily intends to make life hell for. They're people who satisfy the 4 conditions listed in section 2. So the first condition is unlawful or in some way irregular arrival in or entry to the UK. And it specifies what forms that might take. So it would include entering the UK as a person who requires leave to enter but does not have it. It would include arriving with leave to enter that was obtained by deception, entering in breach of a deportation order, entering whilst the person is an excluded person. Particularly problematic, I would say, is arriving in the UK as a person who is required to have entry clearance but does not have entry clearance. And I'm sure there is a debate to be had about who does and does not fall into that category. I mean, on the one hand, entry clearance is not a requirement under the immigration rules for being granted asylum. So an asylum seeker, it may be argued, does not require entry clearance. On the other hand, if you are a visa national, and most asylum seekers would be visa nationals because they come from the list of countries that you have to have a visa to come here, then it may be that simply being from one of those countries requires you to have a visa, and if you don't have it, you meet the first of the conditions. The second condition is entering or arriving in the UK after the Act came into force, was passed, which is the 20th of July 2023. The third condition is not coming directly from the country in which the person's life and liberty is threatened for a refugee convention reason. And the fourth condition is being a person who requires leave to enter or remain in the UK but does not have leave to enter or leave to remain. I mean, I think that is an important condition because it's a condition which is within the Secretary of State's power to change. The Secretary of State can give the person leave to enter or leave to remain. And if the person is given leave to enter or leave to remain, then they cease to meet those conditions and they cease to be a person targeted by the Act. Important there to note that having leave to enter, given leave to enter or leave to remain as an unaccompanied asylum seeker does not result in that condition being disapplied. That's because of section 2(7) of the Act. So what are the consequences of being a person who falls foul of those conditions? I mean, the primary consequence is that the Secretary of State then has a duty to make arrangements for the removal of a person who meets all of those 4 conditions. Well, it's important again to sort of look carefully at what that duty does and does not require of the Secretary of State. So first of all, it's not a duty to remove the person, it's a duty to make arrangements as soon as reasonably practicable to remove the person. Secondly, it would not be, I would say it would not be inconsistent with that duty to make arrangements for the person's removal that are contingent upon a final determination that the person's removal would not be unlawful. And then there is the possibility of being granted leave to enter, which would then bring the duty to remove or to make arrangements for the person's removal to an end. So that's the first consequence of falling foul of those conditions or having those conditions apply. It's likely, however, and this is why there's reference to limbo, it's likely that the real mischief of these provisions will not be that there are suddenly hundreds or thousands of asylum seekers and human rights claimants being summarily removed from the UK. The real mischief is the possibility of being consigned to limbo, because it's likely that even if the Secretary of State has a duty to remove people who meet these 4 conditions, she's going to have a lot of difficulty finding a place to remove them to. So even if the Secretary of State wins in the Supreme Court after today, and it's said that Rwanda is a place to which asylum seekers can generally be removed. And even if Suella Braverman's dream comes true and she's able to see a Daily Telegraph headline saying there's an aeroplane with 2 or 3 people on their way to Rwanda, I mean, it seems that, the press that I've read says that Rwanda's probably going to accept at most about 200 people a year. And yet there are over 36,000 people on the list of people eligible for removal to Rwanda. So that would take hundreds of years to accomplish their removal to Rwanda, if that's the rate of removal. So there is the possibility that there are going to be tens of thousands of people in limbo for hundreds of years if the effect of these provisions is that their human rights and protection claims are to be disregarded. In fact, I wonder, it might be time for the next. In fact, the provisions don't actually say that human rights and protection claims are to be disregarded. If one actually reads the provisions themselves as opposed to the heading, the effect is more qualified and not quite as draconian. So, if another consequence of these 4 conditions applying is the consequence imposed by or required by Section 5.2, which is that the Secretary of State, if the conditions apply, the Secretary of State must declare the protection claim or human rights claim, or both, that the person may have made inadmissible. And the consequence of a claim being declared inadmissible is that it cannot be considered under the immigration rules. It doesn't say the claim is to be treated as if it did not exist. It says that the claim cannot be considered under the immigration rules. And as immigration lawyers, we probably spend a very significant percentage of our time pursuing or helping people to pursue applications outside the immigration rules, asking the Home Office to deal with applications otherwise than under the immigration rules. So it's not actually expressly saying that the claim is to be disregarded, simply that it cannot be considered under the immigration rules. The second consequence of a claim being considered or declared inadmissible is that there is no appeal to the tribunal under Section 82. A declaration that a claim is inadmissible is not a decision which can be appealed under Section 82 of the 2002 Act. So that's what the consequence of a claim being declared inadmissible is. But there are important caveats to that, or qualifications to that, to which it's important to be alert. First of all, is that this section has a very specific definition of human rights claim. The definition of human rights claim that we are used to, which is contained in Section 113 of the 2002 Act, is a claim that being removed from or denied entry to the United Kingdom would be unlawful within the meaning of Section 6 of the Human Rights Act. In other words, it would breach the person's human rights. That's the definition of human rights claim that we're probably used to dealing with. But Section 5 introduces a very specific definition of human rights claim. Section 5.5, human rights claim is a claim that removal from the UK to a country of which the person is a national, or which issued the person with a passport, would be unlawful within the meaning of Section 6. So it's a narrower definition than the definition of human rights claim that we are used to. And I think that has important consequences. So if the person's claim is that if you remove me to a country, I can't think of one. If you remove me to Algeria, I will there suffer torture and otherwise violation of my human rights. That is the kind of claim to which this would apply. That kind of claim would be inadmissible because it's a claim about removal to a particular country. But if the person says that removing me from the United Kingdom, regardless of the country to which I am to be removed, would breach my human rights, because, for example, I've got a right to respect for private life in the UK or a right to respect for my family life here. Or if the person says it would be a breach of Article 4 because as a victim of trafficking, the UK owes me various obligations which can only be discharged in the UK, so I have a right to be in the UK to have those obligations discharged, then it's not a claim that removal to a particular country would breach the person's human rights, it's a claim that removal from the UK would breach the person's human rights, and therefore it is not one which is to be treated as inadmissible. So I think it's very important to have that in mind and to try by all means possible to formulate human rights claims by reference to removal from the UK rather than removal to the country of the person's nationality. And if that is done, then the claim has to be, there's no doubt, the claim has to be considered, and a negative decision on the claim would be the decision appealable to the tribunal under section 82. And I say also that once a person gets a decision that can be appealed under section 82, for example, if the person makes a protection claim and a claim that their Article 3 rights would be breached if they're sent to Algeria, and they also make a claim that their private life rights would be violated by being removed from the United Kingdom, then at least the last of those three claims would not be inadmissible, would have to be determined by the Secretary of State, and if refused, would result in a right of appeal. And I would say that it's at least strongly arguable that in that appeal, the appellant would be able to get the tribunal to consider any matter of potential relevance to the appeal. So that would include the person's claim to be a refugee and entitled to refugee protection in the UK, or the person's claim that their removal to Algeria would be a breach of Article 3. So it would seem to me that once you've got an appeal, then you can get the tribunal to consider any matter that is relevant to the question of whether your removal would be lawful. So that's inadmissibility of claims made by people who meet those four conditions. There's another category of inadmissibility, and whereas all the provisions that I've been talking about so far are not yet in force, there is a category of inadmissibility which arises from provisions that are in force. And I think those are provisions in the 2002 Act, which were first introduced by the 2022 Act and then have been amended by the Act that we've just had. And that's the provision that human rights and asylum claims made by EU nationals and Albanians are to be treated as inadmissible and consequently have no right of appeal to the tribunal. An inadmissibility decision, again, is not an appealable decision. And in respect of the inadmissibility of Albanian and EU claims, I mean, there's a number of important things to note. First of all, I should have shown you this slide actually. There it is. First of all, the definition of human rights claim is the section 113 of the 2002 Act definition. So it's not qualified in the way that I was just talking about. It's anyone who claims that removal from the United Kingdom would breach their human rights. That is a claim which is inadmissible. Secondly, the inadmissibility provisions apply even if the person does not meet those four conditions in section 2. It's merely being an Albanian or EU citizen is enough to cause the application of the inadmissibility provisions. Oddly, what is inadmissible is the asylum claim, whereas the inadmissibility provisions I was talking about originally talk about protection claims. So what is inadmissible for EU and Albanian citizens is merely the Refugee Convention and human rights claim. A humanitarian protection claim is not inadmissible and so would have to be considered in the normal kind of way. And as I say, this provision is already in force. But I would say that inadmissibility decisions under this provision, it's section 80A of the 2002 Act, should be eminently judicially reviewable, at least for the purpose of trying to get a declaration of incompatibility. Because it would seem to me to be obviously discriminatory to deny people the ability to pursue human rights and asylum claims simply because of their nationality, simply because of being Albanian or being an EU citizen. So an Albanian citizen cannot pursue an asylum claim, but a neighbouring person from the neighbouring country, Macedonia, could pursue an asylum claim. And then also for EU citizens. I mean, EU citizens will be prevented from advancing a human rights claim based on having lived for many, many years with their husband or wife or kids in the UK. Simply being an EU citizen prevents that claim from being considered under the rules, denies them access to an appeal, whereas an American person pursuing exactly the same kind of claim would be able to have it considered by the Home Office and would be able to appeal if it's refused. So that would seem like eminently amenable, at least to a declaration of incompatibility, which, as I say, would probably not have been worth the paper it's probably would not be worth the paper it's written on if Suella Braverman is the Home Secretary. In fact, she would probably welcome it as enabling a confrontation with the ECHR. But once there is a new government, as hopefully there soon will be, then it would be a matter of significance. And I think it's also a matter of significance for the purpose of interim remedies that I'll come on to in a moment. So, as I was suggesting earlier, in relation to inadmissible human rights claims, the Act does not say a human rights claim will not be considered. It merely says it will not be considered under the immigration rules. And I do not think that the Act can properly be interpreted as meaning that such a human rights claim has to be disregarded. And it's not just me saying that I think it should not be disregarded. I think there is something in the Act. Yes. Section 30 of the Illegal Migration Act introduces a new Section 8AA into the 1971 Act, which is partially in force already. And it does have already some malevolent kind of consequences in that it denies people to whom those four conditions apply. It denies them access to settlement, to indefinite leave to remain, and it already does that, unless denying them indefinite leave to remain would breach their human rights. But otherwise, limited leave to remain is all that a person can acquire under this provision, as a result of this provision, if they meet the four conditions. And for the purposes of this Section 8AA, although Section 2, which contains those four provisions about irregular migration to the UK, although that is not yet in force, for the purposes of this provision, Section 8AA, it is to be treated as if it is in force. Except that it applies to people who arrived earlier than 20th of July 2023. It applies in respect of people who arrived at an earlier date that I forgot to write down. It was a date sometime in March 2023. So that's the bad aspect of Section 8AA. But what it also includes, and this is not yet in force because it'll come in when all the provisions come in, but it includes subsection 4, which says that the Secretary of State may give the person limited leave to remain in the United Kingdom if A, the Secretary of State considers that failure to do so would contravene the United Kingdom's obligations under the Human Rights Convention or any other international agreement to which the United Kingdom is a party. So that would include International agreements to which that is referring would include the Refugee Convention, for example, or the Council of Europe Convention Against Trafficking. So if it would be a breach of the UK's obligations under the Refugee Convention, for example, or ECAT, then the Secretary of State may, and I would say that's a may which can be interpreted as a must, give the person limited leave to remain. And the fact that there is that statutory provision there means that even though an inadmissible protection or human rights claim may not be considered under the immigration rules, it can be, and I would say must be, considered under this statutory provision. And that is, again, another reason why, well, that is partly a reason why it's important to frame the human rights claim and, if possible, the protection claim by reference to obligations on the UK to allow the person to stay in the UK, move away from framing it by reference to the harm that will befall the person if they go to their country of nationality. So, for example, in the context of the Refugee Convention, yes, of course, one has to establish a risk of refoulement, and that would be part of the claim. But one would also be wanting to highlight the various positive obligations under the Refugee Convention that would be breached if the person is not given limited leave to remain. And don't forget, there's a huge array of positive rights that the Refugee Convention confers, such as the right to take employment, the right to normal kind of social welfare benefits, the right to education, the right to free movement within the country of asylum. Those are all positive rights that the Refugee Convention confers. So that if a person is faced with a prolonged or indeterminate or infinite period of time in limbo, that would be, I would say, a breach of the UK's obligations under the Refugee Convention, which are obligations to make sure that a refugee enjoys those various rights. And then think similarly about human rights claims and the ways in which they can be framed as imposing obligations on the UK to let the person stay, not just not to send them to their country of nationality, but to let them stay in the UK. So claims formulated in that way, first of all, they may avoid being treated as inadmissible in the first place, but even if they don't avoid inadmissibility, they will engage this statutory provision and require the Secretary of State to deal with them. So that's section 8AA. And then there's this real beauty of a section, which is section 54, which applies to any court proceedings relating to a decision to remove a person from the United Kingdom under this Act. And the consequence of section 54 applying is subsection 3. The court or tribunal may not grant an interim remedy that prevents or delays, or that has the effect of preventing or delaying the removal of the person from the United Kingdom in pursuance of that decision. So on the face of it, that would seem to prevent the upper tribunal or the High Court from granting injunctions to stop a person's removal from the United Kingdom. But again, I would say that there is potentially a way to avoid that consequence if the court proceedings relate not to a decision to remove the person from the United Kingdom, but to a decision refusing to grant the person leave to remain in the United Kingdom. So again, if the claim, the protection claim or the human rights claim is articulated in the way that I've been suggesting, so it's by reference to the person's claimed right to stay in the United Kingdom, not a right to avoid being removed, but to stay in the UK. If it's possible to identify positive obligations on the UK to let the person stay, whether that is obligations arising under the Refugee Convention because they need to be given a right to work and so on, or obligations because they've got a right to respect for private or family life in the UK, or because the person's a victim of trafficking who has has a right to receive support and assistance in the UK, then a judicial review claim, if that claim doesn't succeed, a judicial review claim could be brought, which relates to a decision to refuse the person leave to remain in the UK, not a challenge to a decision to remove the person. So if the judicial review proceedings are of that nature, then it may well be said that subsection 54 does not have any application to the proceedings at all. And if section 54 does not apply, then subsection 3 does not apply either. And so the court or tribunal in which you challenge the refusal of leave to remain would still have the power to grant an interim remedy if the person is being faced with removal before they can conclude their claim for judicial review. And I mean, that does, I mean, I would say that that interpretation may find, or I would argue that it should find favour, because, I mean, the right of access to the court is a fundamental constitutional right, which people have had. They had the right before the UK signed up to the ECHR, and they still have that right even if these provisions come into effect. It's a fundamental constitutional right. And it's a well-established principle that Parliament may legislate to take away fundamental constitutional rights. But if legislation is intended to have that effect, it has to be in the most clear and unambiguous, unequivocal terms that that is what the legislation is doing. And I would say that this contains sufficient ambiguity, at least, to be able to say that it does not have the effect of cutting down people's constitutional right of access to the court when they are challenging not a decision to remove them, but a decision to refuse them leave to remain. So that is what I had to say about Limbo and all of that.
Thank you, Ronan. Next up we have Ollie Persey, who has a broad and relevant public law and human rights practice spanning age assessments, asylum support, welfare benefits and health and social care, and so he's very well placed to talk about the provisions in the Act concerning age assessments. Thanks, Ollie.
Thanks very much, Nadia. A couple of preliminary points. First point is I went to the dentist earlier today and my mouth is slightly numb. So if I sound slightly odd this evening, apologies in advance. The second is I had the great assistance of a presentation from Nadia in preparing for tonight. So I don't want to pass off too much of her work as mine. So credit to Nadia, and also blame to Nadia if any of this is wrong. So, what am I going to be speaking to you about? Well, I'm going to be going through what actually an age assessment is, because I appreciate some of you here are not age assessment focused practitioners, but maybe here because of the sort of broader Illegal Migration Act issues being raised in this talk. So I will briefly go through that. I'll go through NABA and how certain reforms from NABA have been sort of kicked into the long grass, thankfully, and the Illegal Migration Act, and look at what's scarily on the horizon in terms of scientific methods, in particular, to assess age. So, the fundamentals, what is an age assessment and why is age important? So, on arrival to the UK, there is generally a short form age assessment by the Home Office, which isn't worth the paper it's written on. There was disclosure in the recent unaccompanied asylum-seeking children in hotels litigation, an independent report commissioned by the Home Office, which was damning of the quality of Home Office age assessments as being done by unqualified people who, and essentially the assessments are of poor quality. However, they can set in train sort of disastrous consequences for children, because those age assessments are given weight by local authorities who then often adopt a Home Office poorly assessed decision and fail to provide relevant and necessary support, particularly under the Children Act 1989. It is obviously relevant to the question of detention and removal. Children Act support, so an unaccompanied asylum-seeking child, if you can establish they're a child, is invariably a child in need, entitled to support under, inter alia, Section 20 Children Act. Children and Families Act are flagged up there, which people may be slightly less familiar with, which is principally the special educational needs duties upon local authorities. Interestingly, they extend up to 25. So if you're assessing age as a precedent fact, and it's important to have a look at Children and Families Act, because if your child or young person has been refused an age assessment on the basis of being substantially over 18, they may not be substantially over 25. So that may be a line of attack on a local authority decision, particularly a refusal to undertake a full and compliant age assessment, and I'll explain what that means for those who are unfamiliar. And then in terms of access to accommodation, if you're over 16, under 16, regulated placements, age is important. So age as precedent fact comes from a case of Croydon, LB against Croydon. Age is a question of objective fact, and it is one for the courts to look at and assess themselves. It makes age assessment, JR, the rather unusual breed of judicial review, and I can see some raised eyebrows in recognition of that oddity in the back of the room. Essentially, there is a lower permission threshold, and then you get transferred to the upper tribunal for a trial. And that may sound very odd to people who are used to sort of bread and butter judicial reviews of A, permission threshold being a bit higher, and B, not an intensive investigation of the facts by the judge hearing the case. So often you plead the conventional grounds of judicial review, but you will just be essentially saying, this is wrong as a matter of fact, because this is a child. And when you get to the upper tribunal, a lot of your evidence will be, look, they're clearly a child. This is their teacher who had lots of interactions with them, etc., etc. Preparing for an age assessment judicial review and going to trial on an age assessment judicial review is entirely different to an ordinary judicial review, which can make it feel a little bit uncomfortable if it's a new area to you. In terms of Merton age compliant assessments, that oddly enough comes from the case of B against Merton, and it sort of set out criteria that people perhaps incorrectly started to identify as more of a checklist of what would be a compliant age assessment. Recent case law, which I'll come on to in a minute, is clear that it is not really a tick box exercise about whether it's a Merton compliant age assessment, but it is one of substance and the quality of inquiry dictated to by a Thameside standard. So I'm not going to go through the points on the PowerPoint presentation in detail, partly because you can all read them, and you'll get the slides later. But this was meant to set out safeguards for what is a fair and robust age assessment and what would underpin a robust inquiry that would be rational. So that includes providing adequate reasons. Let's get through that as well. There's plenty of case law deprecating what is fundamentally a racist approach to age by local authorities, which we will all have seen if we've seen an age assessment, which is comments on build, height, Adam's apple, facial hair, receding hairlines, etc., etc. And you see the most preposterous evidence being cited by local authorities in pseudo-scientific analysis. There was a recent upper tribunal case which relied on shaving, details from a shaving company. It's absolutely bonkers. I was issued an age assessment judicial review earlier this week, which linked to some extremely dodgy American for-profit health sites about skin aging and how you combat aging skin, which was trying to sell skin cream. That is the quality of evidence being relied upon by local authorities. And it's quite shocking, but you do need to have a positive case that your child or young person is the age they say they are to succeed at trial. As I said earlier, it's a lower permission threshold to get over and then transfer into the upper tribunal jurisdiction. But you do need to have that positive case, and it's important to have that positive case set out from the beginning, if at all possible. So as I alluded to earlier, HAM deprecates this idea of a checklist, and that's point 4 on that list. And it's essentially bringing it all back to the idea of actually what is this rational assessment consistent with the Thameside duty of inquiry, which is a context-sensitive duty, but it is to equip a decision maker with all the adequate information to make a relevant decision, which requires positive inquiries, so they have all the relevant information to hand, but it is ultimately a rationality standard. And on to the Nationalities and Borders Act, which now feels like a long time ago and was obviously the landmark piece of legislation that would stop the small boats, solve the immigration crisis, etc., that Priti Patel, who we all now sort of miss, said was the sort of landmark, flagship, whatever cliche she used, piece of legislation that would solve all of the often imagined problems that he talked about. I'm again going to briefly canter through these. I need to give you a health warning that lots of these changes are possibly never happening. And your day-to-day practice may not be affected by the Act of Parliament that was Priti Patel's work of art. Ditto, I suspect, some of, or much of, the Illegal Migration Act provisions in relation to age assessment will, in fact, end up being kicked into the long grass. But let's go through them so that you see them, but I will not spend too much time on them. So there is actually this NARB, National Age Assessment Board. I understand they're having an extremely hard time recruiting social workers because social workers have considered it inconsistent with their duties, their ethical obligations, and that there's a fundamental conflict of interest to be a social worker working for the Home Office, especially in the current climate, where there's a strong incentive to not recognise children as children and actually treat children in cruel ways. We saw the sort of horrible diktat from Robert Buckland in relation to painting over that mural. How can you be a social worker acting in an ethical and responsible way in that environment? Section 50 applies when an age assessment, when an LA needs to know the age of an age disputed person, or the Secretary of State notifies the local authority it has doubts as to the age of an age disputed person, and that the LA has exercised functions under the Children Act 1989. And this is the start of a theme which is continued in the Illegal Migration Act of curtailing and limiting Children Act support. And you'll see that with some of the reforms in relation to powers to accommodate in a hotel accommodation that were introduced by the Illegal Migration Act. There is a focus, I think I may have said Buckland when I meant Jenrick earlier, by the way, just to correct myself, not horrible Robert Buckland, horrible Robert Jenrick. Robert Buckland has actually been saying some positive things about the ECHR, so apologies if he's watching. Where was I? When that occurs and the Home Office wants to sort of the child or young person to be age assessed, has to refer that under section 50, there has to be a referral of the age disputed person to a designated person, i.e. this new NARB, to conduct an age assessment themselves or explain why that age assessment is not necessary, i.e. the child is clearly a child. When that designated person or this new board conducts the age assessment on behalf of the Home Secretary, it's binding, but not vice versa. When the local authority conducts an age assessment or confirms that one is necessary, it must provide evidence to the Secretary of State that the Secretary of State can consider the decision and presumably take enforcement action if so chosen. There are some concerns, obvious concerns, particularly the second point on institutional pressure, which I've alluded to already. There are issues with the burden of proof and departing from the sort of child-focused approach and the benefit of the doubt on burden of proof. Persons subject to immigration control, query whether this is binding, what impact this has on LAs. Could you have this divergence of local authority assessment and Home Office assessment? I think it's something that's going to be sort of one of the oddities in the Act that's going to play out in practice, potentially. Now, scientific methods. I'm going to come on to the draft regulations later, but Section 52 caused considerable concern when this was passing through Parliament. Scientific methods are pseudoscience and potentially extremely harmful to children. Imaging technology presumably means X-rays of kids. It is not safe and it is not cogent. And I'll briefly move on to the recommendations and what's happening with the statutory instruments that are progressing through Parliament and are not in force yet. So there was an interim report of the advisory committee which made a number of recommendations. They're on the screen. I'm not going to read them out. The use of ionising radiation must be limited, but that's still endorsing the use of ionising radiation potentially on kids, with the ultimate aim of eradicating its use. But we've all seen with Home Office practices previously that have been introduced as like a backstop, that it becomes the normality and entrenched into a system. Open the gateways for this and it will become normalised. Where possible, the radiation dose should be limited. All of this is setting out justification for the use of appalling practices, which hopefully medical professionals who are involved with this will resist in forceful terms as being against their ethical obligations. So I did give you sort of the heads up that some of this might not actually happen, which is obviously good news. And the Tribunal Procedure Committee has been a very helpful bulwark against the move, against some of the reforms. And we've seen that previously with detained fast track. But in relation to reforms to age assessments, there was a big concern about the move of age assessment judicial reviews currently in the upper tribunal, which is better funded work. So by that I mean sustainably funded work for practitioners moving into the first tier tribunal without sufficient legal aid in place for them for that work to be sustainable anymore, which would ultimately mean that providers would not be able to justify taking on as many of these cases as they currently take on, which obviously has obvious access to justice implications for very vulnerable people. That is a hyperlink, so when you get the slides, you'll be able to click and read in full what it says. But in summary, the government no longer intends, at least in the short term, to bring the relevant provisions of NABA into force, and that's partly because of pushback from the TPC. It's sort of a wait and see. It could still happen. There are regulations progressing, the use of scientific methods, etc. It's not all over, but the move to the first tier tribunal isn't happening at the moment. And in principle, moving into the first tier tribunal wouldn't necessarily be a bad thing. It's an oddity that upper tribunal is still exercising a JR jurisdiction and it's a trial, and you have to go through this oddity of getting permission from the admin court first and then transferring, there would be some logic to it just being an appeal. It shouldn't be in the IAC. It should be in the Health, Education and Social Care Chamber if it's going into the first tier tribunal, where if you're having, for example, an education healthcare plan appeal, you have expert panel members who have relevant backgrounds, be it educational psychologists, social workers, etc., who are much better placed to deal with the evidence than, say, an immigration judge, bluntly. So again, I'm not going to go through this in any detail, but yeah, I've told you that much of this has been kicked into the long grass. I mean, it may well reappear at some point, and they can't let guard down completely, but it's not in force yet. Again, updated caseworker guidance, not going to go through in the interest of time. It will be available for you to read at a later point. So coming to the actual topic of tonight's talk, the Legal Migration Act. There are further reforms to the age assessment process, including the removal of right to appeal decision, allows removal of person while any judicial review challenge is ongoing. Section 58, I think, is particularly concerning. Sort of the consequences of withholding consent for scientific tests. So, okay, you have to agree to, potentially you will have to agree to ionizing radiation as a child, or an adverse inference will be drawn. Pretty extraordinary stuff. I think subsection 4 is probably the point I want to direct you to in particular, because we know that the purpose of the IMA, the overarching purpose of it, is to facilitate removal and make it easier to remove. And it does not prevent the exercise of any duty or power under that to make arrangements for the person's removal from the United Kingdom. So all of this arrangements for removal will continue. Again, scientific methods.
Sorry, guys.
No worries. Oh, I can hear myself. So weird. This was the provision I was talking about earlier. There's obviously litigation ongoing about the use of hotels for unaccompanied asylum-seeking children, which are being used to bypass the National Transfer Scheme. So briefly, for those that are unfamiliar, the National Transfer Scheme is the scheme that was provided for by the Immigration Act 2016, which creates the Parliament power for the Home Secretary to design a national transfer scheme, which would facilitate the equitable redistribution of unaccompanied asylum-seeking children around the country, so that instead of all being in Kent or Hillingdon, where obviously Dover and Heathrow are, they would be moved quickly whilst in continuous local authority support to other areas of the country, which would be consistent with the best interests of the child being protected at all times. In recognition that invariably an unaccompanied asylum-seeking child is a child in need who deserves protection and support under the Children Act. Instead, the Home Secretary has been bypassing that national transfer scheme by the use of hotels, principally on the south coast of England, including in Brighton. And Mr. Justice Chamberlain declared the bypassing of the national transfer scheme as to be unlawful. And I act for one of the claimants in that case. We're now 7 hearings in the High Court, and we've got a further relief hearing, trying to sort of case manage the sort of shutdown of hotels for use of unaccompanied asylum-seeking children. This power and the sort of suite of powers associated with it is essentially, on the face of it, looks like creating powers for the Home Office to accommodate unaccompanied asylum-seeking children and fulfil the role of local authority that should be for local authorities. But we saw in the Medway judicial review of the Home Office, the Divisional Court was quite clear. So Medway judicially reviews the mandation of the National Transfer Scheme on the basis that they would be unduly prejudiced. The court was clear. The Home Office is not institutionally competent to carry out the role of a local authority in supporting an unaccompanied asylum-seeking child. So these provisions are deeply concerning, and it will be interesting to see how they interact with the judgment in the ECPAT UK litigation, and what happens going forwards in terms of children being effectively removed from continuous local authority support. So we see the crackdown on age assessments and the sort of tightening up of age assessment as part of a suite of changes, which is essentially designed to squeeze unaccompanied asylum-seeking children out of local authority support. And it all links together. It's going to be harder to challenge a dodgy Home Office age assessment. That is the crux of what is happening here. And be it sort of interference with the sort of legal aid provider base by moving it to the FTT, be it use of scientific methods, and which obviously may seem heinous and therefore someone refuses, and the adverse inference that's drawn from that. It's an interlocking picture of hostility to unaccompanied children, which will make it harder for them to assert their rights as children entitled to support, which is entirely non-contingent on immigration status, as was made very clear by Mr. Justice Chamberlain in finding Kent's cap on unaccompanied asylum-seeking children under their protocol with the Home Office to be unlawful. The whole design is to cut down on local authorities' ability and incentive to support children. So it's conscious of actually going over time quite considerably, so I will wrap up quite shortly. It's a work in progress, all of this. So the government has now published a justification decision scientific age imaging regulations. It's subject to affirmative resolution procedure, which is arguably not worth the paper it's written on, but is the highest level of parliamentary scrutiny a statutory instrument can get. So it could theoretically not survive Parliament. That hasn't happened since the 70s. So you pass that procedure. It's called affirmative resolution, but it's an up or down vote, and the government obviously has a majority. We will see, I think it's worth keeping an eye on those regulations and see actually whether they do somehow end up being kicked into the long grass too. And I put some links at the bottom of this slide so you can actually track how they're progressing through Parliament. So there are two pieces of legislation that I think you do need to keep an eye on. The immigration age assessment regs and the scrutiny regs that the justification decisions, scientific age imaging regulations. You need to keep an eye on those, and they are progressing through Parliament. But obviously very concerning in terms of the use of X-ray, radiographic imaging, etc. That is all I have time for. I'll be happy to take any questions at the end. Thank you very much.
Thank you, Ollie. Next up we have Emma Fitzsimons, who will be discussing the provisions in the Act concerning trafficking. And Emma's background makes her very well placed to do so.
Thank you. Thanks, Nadia. Hi, everyone. Like Nadia said, I'm going to talk about the modern slavery provisions. Thanks for bearing with us. I know it's quite a heavy act and it's already 7 p.m. If you are following this in the Act online, the trafficking provisions are sections 22 to 29, so it just might be useful if you're having a look at that. But essentially what the government has done in this Act is to introduce new measures that roll back protections for victims of trafficking. And on this slide is an extract from the government's policy papers as the Act was going through Parliament. And you can see there that in the first paragraph, the government has stated that its intention is that when someone has entered the UK illegally and is identified as a potential victim of modern slavery, so has a positive reasonable grounds decision, we will ensure that they are returned home or to another state away from those who traffic them. So that immediately creates problems because victims of trafficking are supposed to go through a two-stage process and have their conclusive grounds decision, and then they're supposed to be considered for temporary leave, what was previously discretionary leave. And we can see that the reason the government puts forward for this rollback of rights is because it has framed the small boats crisis as a threat to public order that is sufficient to justify departure from our obligations under ECAT and Article 4. And so we'll come on to look at why, in fact, this is, in my opinion, a misreading of what public order means in ECAT in any event. Ronan's already referred to the very draconian nature of Section 1 of the Act, which outlines the purposes of the Act. And I just wanted to flag in general as well for trafficking victims, you can see that the text actually specifies that they're going to provide for protections and entitlements to assistance and support which are available to victims of trafficking, not to apply, subject to people who are subject to the removal duty. And I think that's quite a remarkable policy statement from government to put in its primary legislation. And in addition, you can see subparagraph 4 talks about they're going to widen the definition of public order, and they're going to widen who's caught by basically the public order disqualification provisions of the Nationality and Borders Act as well. And then finally, as Ronan's already alluded to, Section 1.5 provides that the courts are not empowered to use the Section 3 duty to interpret legislation compatibly when scrutinising these provisions. And that's going to have a particular impact in terms of a conflict in trafficking cases, because we've already seen that Article 4 has proved to be a very useful interpretive tool for the courts, even when dealing with ECAT. And that's because Article 4 is directly effective by virtue of Section 6 of the Human Rights Act, whereas ECAT is still an international treaty and it has to be given effect through statutory guidance, which the Secretary of State can change at any time, which she does. So we are setting up for a real interesting and quite complicated argument about the relevance, I think, of Article 4 in the compatibility of these provisions with ECAT as well. So the first thing I should say that the Act does, it does three things for trafficking victims: that it's removal, disqualification from protection, and exclusion from support. So the first thing to look at is removal of potential victims of trafficking. So if you've got a victim of trafficking who comes under the duty to remove criteria in Section 2.1, so if they've entered illegally essentially since the 20th of July 2023 and they don't have leave to remain, then the Secretary of State will be under a statutory duty to make arrangements for their removal. There is a very narrow carve out, and we'll come on to see that that is provided for at Section 22.2. But you can immediately see massive problems with the notion that people are going to be liable to removal even with a positive reasonable grounds decision, because you're stopping the investigatory process before you've identified whether they are in fact a victim of trafficking. Very often, and for those of you that have many clients that have been trafficked, they may well have been trafficked to the UK. So they're being punished for the journey and the lack of regular means to get here. And they're being expressly excluded from consideration of their claims in that regard. And that throws up other issues around whether or not it's in fact a penalty for the purposes of ECAT. Article 26 provides for the possibility of non-punishment, and also under Article 31 of the Refugee Convention. And it's worth noting, I think this is quite damning criticism actually from the Trafficking in Persons report from last year, that there's already concern at an international level that trafficking victims in the UK are not being appropriately recognised and that they're being penalised for the fact that they're not coming directly to the UK. And for those of you that use that kind of evidence in your appeals, it might seem quite strange to suddenly be relying upon it in respect of the UK. As I said, there's a narrow carve out under the Act, and that's in Section 22. And essentially what the Act will do is provide that in a limited case where a person is participating in an investigation and where the Secretary of State is of the view that they need to be here in order to further that investigation. And she considers that the balance in terms of the harm, because they pose a threat to public order, and the need for them to be here, whether that harm is outweighed, a person may be exempt from being removed in these cases. So even in the operation of this very narrowly confined exception, you can see further problems, because many victims of trafficking, especially when they've just got a reasonable grounds decision, will not be in a position to participate in any kind of investigation. There are obviously well-recognised barriers to even getting firm instructions from a victim of trafficking, even at a conclusive ground stage, because of the psychological impact of trauma and the experience of being trafficked. It's a lot to ask them to now be participating in a police or other administrative investigation when they're not even sure that they may not be removed from the UK. And as I said, even this restrictive exception is going to be subject to a further test of compelling circumstances, and that's going to be defined by guidance, which isn't in force yet. Happy reading so far. On to the second main effect of the provisions is to exclude trafficking victims from support. And in terms of the provisions for England, these are in section 23. There's also analogous provisions for Scotland and for Wales as well, and Northern Ireland for Scotland, for Northern Ireland. But essentially what section 23 will do is, where a person has a positive reasonable grounds decision and they meet the removal criteria and they're not cooperating, or they're not cooperating and the Secretary of State agrees that they need to be here, then the statutory duty to provide them assistance and support is dispensed with. So again, they're not going to have access to a proper recovery period, they're not going to have access to meaningful support in that time. And then the final main effect is the disqualification from protection provision, which is in section 29. So this builds on what's already in the Nationality and Borders 2022 Act. And essentially it extends the public order disqualification regime, or the PODS regime, as it's been referred to. So previously under the NAB, the Secretary of State had a discretion to impose a POD. Now it's going to be a duty. However, you'll see that there's also again a reference to compelling circumstances. And again, the explanatory notes to the Act say that this is going to form the basis of guidance. The guidance isn't published as of yet. The Act also widens the definition of threat to public order. And so under the NAB Act, it was a foreign criminal automatic deportation level. So anybody who had a 12 months of imprisonment sentence, as well as other prescribed behaviour, like an attempt to be involved in a terrorist organisation, or if there was a TPIM or another kind of order in place. But for our purposes, the UK Borders Act was the main threshold. That now has been relaxed so that any period of imprisonment will be sufficient for public order disqualification. So you don't even need to have 12 months anymore. So anybody who's also potentially caught by discretionary deportation, non-conducive deports, will be caught by this as well. And then there's just some additional provisions just for completeness of what the definition of a period of imprisonment means here. So you can see here it doesn't count if it's a suspended sentence, but it will count if it's a hospital order, essentially. And then finally, you can see that the section 96(6) provides that disqualification applies irrespective of whether a person has received positive, reasonable grounds decision, including if it was made before they came into force. So potentially catching lots of cases in terms of the expansion of the PODS regime. So then just coming on to think about whether or not these provisions are in fact lawful, it's interesting, the Secretary of State was not able to declare to Parliament that the Act was in fact compatible with the Human Rights Act. And there's not many occasions where ministers have not been able to sign off legislation, pretty rare. As I've alluded to before, there are problems because the Human Rights Act Section 3 duty is going to be disapplied. And also, a real problem with this is that it will disqualify from protection on the basis of mode of arrival, which means there's lots of interesting issues around Articles 4, 3, 13, 14, and also under ECAT. I'm not really sure, I think our screen has an issue here. And the government is alive to these risks because in its Human Rights Memorandum, which it's published alongside the Act, it's taken the position that it thinks that this can be applied in a compatible way with Article 4, but that it requires radical solutions to put a stop to small boats crossing the channel. If we spend a bit of time just thinking about the problems with ECAT, I think just for the purposes of discussion today, two provisions that are worth noting, Article 10 and Article 13. So one of the first immediate problems for clients is going to be that they will be liable to removal after a reasonable grounds decision. And that appears to be completely contrary to what is provided for in Article 10 of ECAT, which provides that you're supposed to have a cooling off period, right? Once they encounter you and they start the investigatory process, you're not supposed to be liable to removal until that process is finished. Otherwise, people will not effectively cooperate because they'll be too frightened. So that makes perfect sense. But as you can see there, that there's clear language in the treaty itself, and also in the explanatory report from Greta, they take the view that you're supposed to suspend removal from the reasonable grounds date onward. There's also the problem with the recovery and reflection period compatibility, because Article 13 requires that the definition of public order, I think, has been misapplied and applied in too broad of a way by the Secretary of State. You can see in particular, so when we looked at the justification, they're relying on a macro level that small boats are crossing the channel. But when you look at the convention and you look at the experts' views on what the convention means, they're of the view that it's intended to apply to victims of trafficking who are illegally present in the state's territory. So the ordinary thinking, the conventional thinking has always been victims of trafficking will be here irregularly because that's part and parcel of the modus operandi of traffickers, and they shouldn't be punished for that. And public order has typically been a specific threat from a specific person, not a general failure of the political classes to find a solution to unsafe routes to migration. And then finally, coming on to it, there are also obviously problems with ECHR compatibility as a result of the new provisions. And the main one, obviously, I think that you come to first of all, is that you've got an absolute obligation to identify and protect victims of trafficking at all stages. That's not going to be possible under this Act. In addition, our own courts recognise that the process of identification is really important for safeguarding people against being re-trafficked. That's obviously not going to happen in cases where people are liable to removal after a reasonable grounds decision. And so some of the foreseeable breaches that we're going to have are breaches of positive obligation to identify, breaches of positive obligation to protect, breach of the positive obligation to investigate a situation of trafficking, because you won't have the full facts yet because people are too scared or they're going to be removed. So I think the final slide that I just wanted to flag up is thinking about discrimination as a potential way of challenging these provisions, because I think the provisions are very draconian, and we also need to think about strategies for protecting a really vulnerable client base. And sometimes I think we need to be a bit more creative when we're thinking about how we can attack provisions like this, especially if we're being faced with obstacles around the ECHR. So the Secretary of State is already aware that there is a real problem that this may indirectly discriminate victims of trafficking, because they're only going to defer removal if you participate in certain kinds of investigations. Obviously, people who are not well, who have mental or physical disabilities, or who have mental health conditions are not going to be in a position to cooperate, and therefore they're deprived of the benefit of having their cases determined here. The government's position is that differential impact is justified and proportionate because of their legitimate aim to reduce crime, generally migration crime. So I think that, again, this is another thing just generally to think about when we're seeing these cases in the event that this comes into force, is we need to be thinking about the kinds of medical evidence that we need for these cases, because we may need to be thinking about not just recovery needs in the usual way and corroborating past trauma, but also why is it that somebody can't effectively participate in an investigation? What kinds of barriers are there to that? Because I think medical expert evidence, as usual, is going to be really important. So thank you for bearing with. Unfortunately, that's the end of my very depressing run through the modern slavery provisions.
Thanks to all our brilliant speakers and for all of you for listening during their very valiant attempts to wade through what is a very dense and ultimately incredibly depressing act. We do have a few minutes left for questions. There are a few that have come up on Zoom from those who are joining remotely. I may go through one of those first and then offer it out to the room so that those online are also included. The first question, and unfortunately I'm going to pass this one on to you, I think, but this may seem to be a simple question, but what does inadmissible really mean? If someone claims asylum, will the UK government still be required to receive and store that application, even if they do not process it? And if so, will individuals still be provided with an asylum registration card and an ASPEN with Section 4 financial support? It's the closest to your topic, I'm sorry.
To be honest, I can't really answer that. Ollie might be able to.
No.
There is specific provision for amending the asylum support regime if you're declared inadmissible.
That's made for the regs though.
Yes, I think it is. I mean, currently, if you would be eligible for Section 4(2) support if you're not admitted. So it may be that those people may be pushed into that cohort down the line.
Yeah, so I can see Section 9, I pulled it up as well. There is provision to make various amendments to various other different things, but nothing else is, nothing very clear about happening. And in terms of storing the application, I mean, I don't think there's any provision under the Act for that.
I mean, no, but surely they would have to store it, otherwise they would sort of be frustrating. That would just be poor governance apart from anything else.
And what they will do with it. Not a simple question at all.
That's more a data protection issue rather than anything else.
Exactly.
Yeah.
Any questions in the room? Yes.
Could I ask the panel, bearing in mind a lot of the Act hasn't come into force, comments about the effectiveness of a declaration might be political. What would be priority areas for judicial review challenge as things stand?
Well, it's not the topic for this evening, but in terms of provisions that have come into force, there's only some of the provisions around detention. And so, perhaps refer you back to that event on it, but there definitely are some provisions already in force on that, and definitely Greg in his presentation set out a number of avenues for challenge on that.
And I'd say also, as I mentioned, the disqualification of Albanian and EU asylum seekers and human rights claimants. I mean, that's in force, although it's in the 2002 Act.
And to repeat what I was saying around in hotels and the undermining of the local authority support, I think we need to see what the fallout is of the ECPAT, Brighton, Kent litigation against the Home Office. But when that's concluded, and that is going to be soon, we are going to be seeing the misuse of the powers that I took you to in the IMA as a way of circumventing the Children Act.
Any other questions in the room? Yes.
Ollie, scientific evidence in age assessments are decisions that were made by the tribunal or the courts in relation to discrediting scientific evidence such as third molars. That I think, is that still a precedent, or is it overridden by the Act?
So the Act creates powers and to And we've seen there's draft regulations in place at the moment to use scientific evidence. Secondary legislation is obviously challengeable by judicial review, and that is actually something that may be worth thinking about in linking back to the previous question. Even before it passes through Parliament, you can challenge regulations still in draft form. We saw that with Public Law Project against Lord Chancellor in terms of the residence test for legal aid. It goes to an ordinary public law challenge of those regulations around the rationality of allowing that type of method of evidence to be used. So I'm not sure it's strictly a question of does it supersede it, override it, displace the precedent. The secondary legislation is amenable to challenge, and I think it could be folded into, I haven't honestly formulated the grounds of challenge to those regulations yet, but I think it could certainly be folded into a sort of Human Rights Act challenge to the secondary legislation, with a view to getting that secondary legislation quashed principally on I said irrationality, but like on a human rights ground basis, possibly on the basis of discrimination, Article 14, although that would be quite difficult because of comparator, possibly on the basis of Article 8 and interference with Article 8 rights. I think you may have difficulty on Article 3, but I think it's worth thinking about very carefully and possibly something for strategic litigation.
Right, thank you all very much. We have finished only 1 minute over time, so thank you all.